In this lecture, we discuss the foundational modern precedents governing state-tribal struggles over jurisdiction in Indian country and specific congressional authorization of state jurisdiction in Indian country. Recall that Indian country is the basic jurisdictional term within which the special rules of federal Indian law apply. Outside of Indian country, with a few exceptions like tribal sovereign immunity from suit and the Indian Child Welfare Act, ordinary United States and state law generally applies to Indians as well as to non-Indians. Recall, too, that a state has no inherent authority within Indian country, as the Supreme Court stated in 1832 in Worcester v. Georgia, where the court articulated a categorical preemption against state power. The state power, the court said, was preempted by tribal sovereignty and by federal supremacy. That is, inherent tribal sovereignty preempted state law and federal supremacy preempted state law. As we see in the reading accompanying this lecture, Congress may delegate some of its plenary authority over Indian affairs to a state, as it did in Public Law 280. As we will see in the next lecture, the modern Supreme Court, in around 1980, began to depart from the categorical exclusion of state authority, allowing some state jurisdiction without congressional authorization. 3 Supreme Court cases provide the modern law foundation for state-tribal struggles over jurisdiction in Indian country. As you will see, despite the departure from Worcester that I just noted, state authority in Indian country remains limited by inherent tribal authority and federal supremacy. We begin with the 1959 case, Williams v. Lee, often described as the first modern Indian law case. Worcester's categorical exclusion of state jurisdiction remained virtually unchanged for a century and a half. Although Justice Black's opinion in Williams v. Lee reached the same conclusion as Worcester, that state jurisdiction is barred in the case, the court articulated the legal rule in different terms. This reframing created a precedential loophole that would allow later courts to diminish tribal authority and expand state authority incrementally, that is, on a case-by-case basis. Mr. Lee was an Indian trader on the Navajo Reservation, licensed by the Bureau of Indian Affairs to operate a trading post. Mr. Lee, a non-Indian, sold goods to tribal members on credit, including Mr. and Mrs. Williams. When the Williams were unable to pay, Lee brought a collection action against them in Arizona State Court. The Arizona Supreme Court held that state courts had jurisdiction over the suit unless Congress expressly forbade that jurisdiction. That decision was reversed by the United States Supreme Court. The court followed its discussion of Worcester's categorical exclusion of state jurisdiction with a discussion of Congress's consistent historical assumption against state authority in Indian country. In that context, he then stated the legal rule using different language than Marshall had in 1832, creating what is now known as the infringement test. Quote, essentially, absent governing acts of Congress, the question has always been whether the state action infringed on the rights of reservation Indians to make their own laws and be ruled by them, end quote. Applying that rule, the court held, to allow the exercise of state jurisdiction here would undermine the authority of tribal courts over reservation affairs, and hence would infringe on the right of Indians to govern themselves. It is immaterial, the court said, that the respondent is not an Indian. He was on the reservation, and the transaction with an Indian took place there. 6 years after the Williams decision, Justice Black wrote the decision in Warren Trading Post Company versus Arizona Tax Commission, a case in which the state of Arizona attempted to levy a tax of 2% on the gross proceeds or sale or gross income of Warren Trading Post Company, a licensed Indian trader on the Navajo Reservation. As in Williams versus Lee, the Arizona Supreme Court held that the state had authority to impose the tax. Again, the United States Supreme Court reversed, holding that the state tax was preempted by federal statutes and the resulting comprehensive federal regulation of Indian traders. According to the court, the federal Indian trader statutes, which began with the Indian Trade and Non-Intercourse Act of 1790, demonstrated congressional intent to ensure no burdens limited trade in Indian country other than those imposed by Congress. The state tax would create such a burden and would frustrate congressional policy. Further, the court noted that the state provided no services to justify the tax, as roads and education were provided by the federal government or the tribe. Similarly, in 1973, Justice Thurgood Marshall wrote a decision reversing the Arizona Appellate Court's approval of a state income tax imposed on Navajo citizens whose income was derived wholly on their reservation. The state court incorrectly applied the infringement test from Williams v. Lee and ignored relevant treaties and statutes. McClanahan provides a valuable history of the exclusion of state authority from Indian country, noting that while not static, there remain two bases for that exclusion: inherent tribal sovereignty and federal preemption. The court noted the recent trend away from relying primarily on inherent tribal sovereignty in favor of federal supremacy. Specifically, the court noted that tribal sovereignty provides a backdrop against which federal statutes and regulations must be read when determining whether those statutes preempt state authority. Further, the court applied the Indian canons of construction to treaties and statutes, resolving ambiguities in favor of the Indians. The Supreme Court noted that the Arizona Enabling Act expressly disclaimed state authority over Indian lands, and Congress intended to maintain the tax-exempt status of reservation lands. Finally, even though Arizona was attempting to tax an individual rather than infringing on tribal self-government, the court emphasized that Ms. McClanahan's activities were entirely within the sphere of federal-tribal relations. It so held because she was a tribal member earning income on tribal lands, so there was no non-Indian interest to consider, as was the case in Williams v. Lee. In the end, the McClanahan decision makes clear that absent explicit authorization by Congress, a state may not impose a tax on Indians within Indian country. Our second topic is congressional authorization of state jurisdiction in Indian country. Public Law 280 is the primary example of Congress authorizing jurisdiction in Indian country for a state. Passed in 1953, PL 280, as it is often described, embodies the termination-era policies that predominated from approximately 1946 until around 1970. Although Congress had delegated authority to states in specific regions prior to PL 280, that statute was more comprehensive, withdrawing federal criminal jurisdiction on reservations in 6 states, authorizing state criminal jurisdiction, and allowing those states to hear civil cases arising against Indians in Indian country. The 6 mandatory jurisdiction states, so called because there was no tribal consent provision for the Act's first 15 years, are Alaska, California, Minnesota, Nebraska, Oregon, and Wisconsin. 10 other states accepted some degree of jurisdiction, as the book describes. As the text notes, PL 280 fundamentally reworks bedrock assumptions of federal Indian law, allowing the states, which, as Kagama famously said, historically have been viewed as the tribe's deadliest enemies, to assume jurisdiction in Indian country. How should we apply the Indian canons of construction to Public Law 280 and similar statutes? Should we apply it narrowly in order to interpret it in favor of the Indians, or should we apply it broadly because the Congress that passed it intended it to be part of a broader termination policy? Moreover, states were not given federal funds to increase policing on Indian lands. We would now call this an unfunded mandate. Did Public Law 280 give states taxing authorities to fund their activities on Indian lands? That is the question presented in Bryan v. Itasca County, decided by the Supreme Court in 1976. Except as expressly excluded in the statute, did the grant of civil jurisdiction in Public Law 280 include the state power to tax Indians in Indian country? Russell Bryan, a citizen of the Minnesota Chippewa tribe, challenged a state tax on his mobile home. Note, this was a personal property tax because the property was movable and was not affixed to the land. The real property, the land, and anything embedded in or affixed thereto, was explicitly tax exempt. The state Supreme Court held the tax valid because, by implication, the exclusion of real property taxes must have meant that other taxes by the state were acceptable. the Supreme Court reversed. The court cited McClanahan for the proposition that the tax was presumptively invalid without congressional approval, and the statute did not provide that approval. The legislative history showed Congress's primary concern was lawlessness in Indian country, and there was no mention at all in the legislative history of a delegation of taxing authority to states. This is a significant omission given that it would fundamentally change long-standing rules about taxation in Indian country. Further, contemporary Indian policy favored self-determination, not termination, because this case arose in 1976 after we had abandoned termination policy in favor of, as Nixon described, self-determination without termination. Further, the Indian canons of construction required the explicit abrogation of tribal reserved rights and immunities according to the court. Accordingly, the court held that Public Law 280 provided state adjudicatory authority as well as criminal authority, but it did not allow general state taxation of or general civil regulatory authority over Indians in Indian country. California versus the Cabazon Band of Mission Indians addresses the question begged by the Bryan case. If Public Law 280 gave states criminal jurisdiction, but not civil regulatory jurisdiction, how do we know when the state is validly exercising criminal power or invalidly exercising civil regulatory power? The answer is not found in the nature of the penalty itself or the enforcement measure, because some civil actions can be enforced by fines and the like in the same way that criminal statutes can be. In Cabazon, California attempted to impose penal code provisions on tribes offering bingo and card games to the public. The California Code did not prohibit bingo, but imposed restrictions on such games, including allowing charitable organizations to conduct them for their members so long as there were no wages or profits and so long as prizes were limited. Discussing Bryan, the court applied a criminal prohibitory, civil regulatory distinction. That is, if the conduct was entirely prohibited, then it was considered criminal and could be banned by a Public Law 280 state. If the conduct was allowed but subject to regulation, then it was in the arena of civil regulatory power and not part of a delegation of authority found in Public Law 280. In this case, California itself operated a lottery, and it allowed pari-mutuel horse race gambling and charitable bingo. Thus, even in a Public Law 280 state like California, tribal gaming operations were permissible. Note that outside a Public Law 280 state, the state would have even less justification to intrude on tribal gaming operations. As you may know, the Cabazon decision led to the Indian Gaming Regulatory Act, which limited tribal gaming but created a federal statutory regime under which gaming has flourished for many, though not all, tribes. Next, we'll discuss state jurisdiction in Indian country without congressional authorization, where we will consider, among other cases, the second portion of the Cabazon decision.